Hello and welcome to Square Live. My name is Alison Lambert and many of you will know me. For those who don't, I'm a barrister at Square Chambers practicing in consumer and trading standards law. Today I'm going to be talking about issues that arise in complex multi-handed cases. The aim of my talk today, which will last about 20 minutes, is to give a brief overview of some of the issues that can arise in these types of cases. Trading standards departments are increasingly investigating and prosecuting complex cases that involve multiple defendants and serious offences. Gone are the days of prosecuting a trader at a boot fair with a rucksack of counterfeit DVDs. Now it is sophisticated frauds and conspiracies. And the issues that arise in cases of this type will not have been frequently encountered and take some adjustment. Firstly, pre-trial issues impacting on the trial. Firstly, the number of defendants that you choose to charge. Whilst it might be tempting to charge 10 defendants, and in some cases entirely justified, you will then have to deal with 10 lots of legal teams. The larger the number of defendants, the more complex and unwieldy a case can become for trading standards, for the jury, and for case and court management. It's very important to remember that if a suspect is not charged, some of the evidence relating to them will not be admissible. This is most pertinent when considering interviews under caution. However, you cannot charge a suspect just because they give really valuable information or point the finger at another in an interview. You can only charge the suspect if the full code test is met, the evidential and public interest tests. What a suspect says about another is not evidence against that person. That is a common mistake to make. If you have a suspect on the periphery who's likely to be able to give valuable evidence, consider whether they should be invited to be a prosecution witness. Whilst that might go against the grain, they are much more likely to be amenable to being a witness if they haven't been dragged in for an interview and don't feel they're a suspect from the outset. However, there are instances where it might only become apparent at interview that they are not particularly implicated but have crucial information, and become invited to become a prosecution witness after the interview and may be willing if it stops them being charged. After charge, there is the obvious implication that they've only agreed to become a prosecution witness to get the charges dropped against them. If a suspect is charged and pleads guilty, they can still give evidence for the prosecution, but they have to do this by turning King's evidence. A note of warning, however, juries do not tend to like such witnesses. With all suspects, care must be taken to analyse any motive for giving evidence against another suspect. You can guarantee that the defence will make as much mileage as they can out of such issues at trial. Obviously, any and all of this may become disclosable in due course. In my view, a maximum number of defendants in one trial to keep it manageable is probably 4. The second issue, pre-trial, is the number of charges. Again, it can be very tempting to lay multiple charges. It is nearly always going to be the case with a lengthy, complex investigation that you'll be out of time to lay CPUTs, and it is unlikely in such cases that the maximum 2-year custody for these offences would be sufficient to represent the criminal behaviour in any event. It is worth keeping in mind that a defendant may offer pleas to CPUTs instead of fraudulent trading or substantive false representations, precisely because of that 2-year custodial maximum for CPUTs. If you are in time, it is worth considering laying CPUTs as an alternative offence, if you're in time, obviously, and the offending behaviour is within CPUTs. One thing to bear in mind that there is case law which states you cannot accept a plea to a CPUT offence if you would have been out of time to lay it in the first place. The third issue is the type of charges. Consider what charges need to be laid to cover the criminality. It is better to charge fraudulent trading as a single count, or maybe more than one count if there are more than one company involved, than to have 50 counts under Section 1 and 2 of the Fraud Act. Great care must be taken not to overload the indictment. Firstly, a judge will not allow it, and 1 or 2 counts are far more simple for a jury to deal with than numerous counts. If charging fraudulent trading, conspiracy to defraud, or statutory conspiracy, it's possible to list the number of ways in which the fraud was said to be committed. Fraudulent trading and conspiracy to defraud and statutory conspiracy are very versatile charges. When you've laid a number of examples, there is no need to prove them all. The jury has to be sure of at least one example on which they are unanimous, or a majority if a majority direction has been given, in order to return a guilty verdict. A further issue is conspiracy. Consider whether you really need to charge a conspiracy, or whether jointly charged fraudulent trading or other offences would suffice. There is a higher hurdle to clear for conspiracy because you have to prove the agreement itself. Whilst this can and usually will be done by circumstantial evidence, as it is very unusual to have actual evidence of a conspiracy, it is potentially creating a more onerous burden. Remember, the penalty for conspiracy is the same as the substantive offence. If you charge a conspiracy and substantive offences, then you may be put to election during the pre-trial or trial process. Charging a conspiracy would not preclude you from accepting pleas to substantive charges at a later date, or substantive offences at a later date. Another issue to consider are split trials. If many defendants are charged, the defence can seek severance from the other defendants. However, one of the most common consequences of charging many defendants is that the court will, of its own volition, order split trials. This causes an absolute minefield for the prosecution and often for the defence too. You cannot present evidence against a trial 2 defendant in trial 1 and vice versa. So, for example, the interview transcript of a trial 2 defendant will not be before the jury in trial 1. This can have a devastating prejudicial effect on the prosecution's ability to present a trial effectively. It also can make the evidence far harder to understand for the jury because there will naturally be gaps. Where there are cutthroat defences, it is very important to have all the defendants in one trial, otherwise you lose the impact of those cutthroat defences. However, if some of your defendants are charged with conspiracy, for example, and some with money laundering only, it's easy to split, as the evidence for that can be separated quite easily. And you can make an application in trial 2 to adduce any convictions from trial 1. We then move to issues that arise during the trial process itself. Firstly, disclosure, the dreaded D word. If you think that all of the disclosure has now been sorted out and we can just crack on with the trial, I'm afraid I have news, and not good news. The most common scenario with complex trials is that counsel will not have been able to devote a large amount of time to the case due to their workload and legal aid issues prior to the trial, and will suddenly, a few weeks before you're ready to start, get a grip on the evidence and the disclosure requests will start flooding in. Another issue during trial, I'm entitling a shifting of sands by the defence. Having said that the defence counsel will probably not embark on a detailed trial preparation at an early stage, there is often a shifting of sands at a very late stage. I've most encountered this in witnesses. Witnesses will have been agreed. Things like the admissions and the jury bundle index will have been agreed. The admissions are a living document, and it's likely that they will not be finalised until the end of the prosecution case and sometimes well into the defence case. But the jury bundle will have been prepared. The most frequent issue I've found is that counsel who will have been agreed the jury bundle index, usually a month or so before the trial starts in order that the prosecution can get it printed for the jury, will then, a few days, more often than not before trial, sometimes on the night before trial, telephone me saying they do not agree certain items in the jury bundle. And then there's a mad dash to fill the bundles before they go to the jury. This is very frustrating, but no matter how much the defence is chased beforehand, this will always happen. The jury bundle should always be printed single-sided so that we can add or remove pages as necessary. And any documents that are disputed or likely to be disputed left in a section at the end of the jury bundle. So again, they can either be subject of legal argument before the judge and can then be removed or added to at will. I mentioned witnesses. The defence will often say they want multiple witnesses warned and then decide, again, often on the day before or sometimes even on the day of evidence, that they do not now need that witness and that evidence can be read or put into the admissions. Additionally, the defence will sometimes decide that a witness they had previously agreed is now needed, and we should be prepared and ready for these things to happen at trial and at the last minute. Another issue is leading and junior counsel. With a large complex case, you are going to need two counsel, with the obvious additional financial burden that places on the public purse. In some cases, you may also need disclosure counsel. This means that it's likely also that each defendant will have two counsel. Therefore, 6 defendants may mean 12 defence counsel, often with silks leading. If the defence have two counsel, it's likely that those for the main defendants will have plenty to do. But those who have two counsel and are further down the indictment may have time to start causing problems for the prosecution. They will have time, particularly once the trial starts, to start going through the unused schedules with a fine tooth comb. And this can be disruptive because you then can get well into trial more disclosure requests coming in. One small point I wanted to make was regarding half-time submissions. And these must be kept in mind. Once we start the trial, we're not out of the woods until we get past half-time, and either there have been no half-time submissions or we've successfully rebutted them. I've mentioned witnesses already as well, with the defence changing their minds about which witnesses they want, often at the last minute. But witness management has been one of the most difficult parts of a trial, particularly in large complex trials. Witnesses will have been told that their attendance cannot be guaranteed on a particular day, and it's likely there will be need for alteration. But witnesses don't seem to take this on board. In my view, they should be told to keep a week free either side of the potential date they are likely to be called. Because one of the issues when you're getting towards the end of the prosecution case is that we cannot call a witness after we've closed our case. So a witness very close to the end who then suddenly says they cannot make it, can they come in 2 weeks' time or 3 weeks' time, for example, probably won't be able to be accommodated. And then the decision will have to be made not to go ahead with that witness. Elderly and vulnerable complainants are another issue frequently encountered in our trials. It's usual to keep the court updated on which witnesses will or might be the subject of a Section 111 Criminal Justice Act application. Those are the hearsay provisions. And the most common ones found in our types of cases are those for deceased witnesses and those for unfit witnesses. These can and do crop up at the last minute with complainants with precarious health issues. In a recent trial I did last year, I had one witness who went from fit to unfit to deceased during the trial. Section 116 deceased applications must have a death certificate to accompany them, and they are quite straightforward. Once that death certificate has been provided and the application made, it is very rare that a court will not allow that witness statement to be read from that witness. Applications for witnesses who are unfit through bodily or mental illness are far more complicated, and they will need more evidence than just a brief letter from a GP saying that they can't attend court. In most cases, it will require a detailed report noting the exact nature of their illness and why they cannot come to court. This may be able to be provided by the GP, but often it will need to be provided by a specialist, a consultant, or other doctor who has been treating the patient outside of the GP system. There's likely to be quite close defence scrutiny and potentially a need to have a witness examined by a psychiatrist if there is suggestion of dementia or illness which could affect their memory or their ability to recall. And this, I've found more recently, also includes renal illness, because that can have effect on cognitive ability and memory. The defence is starting to become quite alive to those types of illnesses or conditions where they feel it could affect the ability of the witness to recall, either when they give their statement or at a later stage. If a witness gives a witness statement or an ABE and there's no suggestion at the time of the ABE of dementia or any similar illness, there should not be too much of an issue if this is subsequently diagnosed. Much will turn on the time frame between the ABE or witness statement and the diagnosis. If the witness becomes unfit through dementia, it is likely that a psychiatrist will need to assess the ABE and then the witness in their current state to establish whether they were competent to give evidence at the time of their ABE. 2 cases I've dealt with in the past, one for Oxford Trading Standards, where the witness gave an ABE, was then diagnosed with dementia many months later and then died prior to trial, required a psychogeriatrician to examine the ABE, look at that witness's medical records and give his opinion that the witness was competent to give evidence at the time of the ABE. In another case for Lincoln Trading Standards, the psychogeriatrician went through the same exercise for a witness and concluded that although the witness was competent, although barely meeting the test in the statute, which is the Youth Justice and Criminal Evidence Act of 1999, it was clear that the answers given were not reliable. And in that situation, we did not proceed with that witness. If there is a witness who has given an ABE interview and they are still competent to give evidence, consideration should be given to the Section 28 application process for their cross-examination to be pre-recorded. Having said that, these applications are quite complex and they should be flagged with the court at the PTPH so that the necessary applications and arrangements can be made. Another issue is the support at court. It's imperative that counsel has support at court. It should be borne in mind that if you're charging numerous defendants and the trial is likely to last some time, that the OIC and someone from the legal department will need to be available every day the court sits in that 3-month period. Having said be available, they don't necessarily need to be available at court, but they need to be available to be able to answer questions and also deal with disclosure matters as and when they arise. There is also, particularly at the start of any trial, when the prosecution is working full tilt to get their case moving and through to half time, that until the end of that prosecution case, there will be much to be done. There will be evening and weekend work for trading standards, legal and counsel to do. Contact should be made with the court prior to the trial to secure a room for the prosecution, and a printer should be provided by trading standards. One thing to bear in mind is that witness care services vary hugely in different courts. Don't assume witness care will make tea for your witness and bring them up to court when their evidence is needed. Southwark doesn't provide that anymore at all, and the prosecution is expected to come down to the witness room to get their witness and bring them back up to court when the court is ready to hear their evidence. Other courts, having said that, are extremely helpful and will do all of that and more. One area that frequently crops up is the area regarding pleas. Once in trial, keep an open mind about any pleas offered by the defence. Remember, by the time we get to that stage, we're at the court door and defendants may be having a change of heart. However, remember that the defence counsel is trying to get the best possible outcome for his or her client. They will not, except in very rare circumstances and on very rare occasions, offer pleas to all of the counts on an indictment against their client. For example, if the client is charged with a conspiracy totaling, for example, £500,000, they will probably seek to offer substantives which represent the sales their client made to bring the value of the offending down. This is why it is done. And it's done so that they can perhaps move it down in the sentencing guidelines and get a lesser sentence for their client. It's very important to consider the reasons why the case is brought. The case is brought to obtain convictions and get redress for the victims. Any case, no matter how strong it is at the mercy of the jury, and juries can and are unpredictable. If there is a plea, even to a lesser offence, or to a lesser amount, a vulnerable victim might be spared, albeit at the last moment, from coming to court and giving evidence. Pleas from one defendant, even if they're not to everything on the indictment, often provide a domino effect for other defendants. And as I've mentioned, an application can be made on any plea for that conviction to go before the jury against the remaining defendants. The last topic I just want to speak to you about is victim impact statements. I cannot underestimate the importance of these. All the victims should be asked if they would like to write one, and if there is a conviction, whether they would like to come to court to read it for themselves. If they don't want to come to court to read it for themselves, then prosecution counsel will read it for them during the sentencing process. This gives the prosecution the opportunity to underline the harm caused and invite the court in some cases to move up within the sentencing guideline band, and sometimes the court will even move up into the next band. So it's therefore very important. It should also be remembered that whilst a victim might in their witness statement have mentioned an impact that the events have had on them, it is extremely likely that defence will object to that being before a jury whilst they give their actual evidence. So the effect on them may not become fully known until the stage of sentencing. I have had judges who have commented that they had not realised, for example, in a case where the offending had been instigated by the use of cold calls, one of the victims said that now every time the phone rang, they started shaking and they got very distressed because they were terrified it might be someone else ringing to scam them. And the judge said he was very taken by that when he heard that read out in court, and that had not occurred to him. That's just a few of the brief things that I can cover in this Gough Square Live presentation on the issues that you might encounter in complex and lengthy trials. I'd like to say thank you for listening in. Please feel free to get in touch with me by email with any queries you might have, and I will try my best to provide you with an answer. Finally, please tune in to our next instalment of Gough Square Live, which is on the 2nd of July of this year, when David Travers, King's Counsel, will be speaking on a topic that will be revealed soon. Thank you for listening, and good morning to you all.